Audio check. right, good morning, everybody. My name is Vice Chairman David Arconti. With me today is Commissioner Karen. Today we'll be hearing oral arguments with respect to proposed final decision in Docket 241004, the application of United Illuminating Company to amend its rate schedule. As a reminder, the evidentiary record has closed. So the purpose of today is to receive oral argument from any party or intervener with respect to the proposed final decision. This is not an opportunity to introduce new evidence. The commissioners have read each party's intervener's written exceptions in full, so we will ask that you please refrain from summarizing your written exceptions as we review them, and they are in the record. We will do 2 rounds of oral argument. We'll take the first round and then allow for a brief rebuttal for the second round. So first, we will take appearances. So any attorney representing a party intervener who intends to participate in oral arguments this morning, please approach the microphone and state your name and the party on behalf of whom you will be presenting argument.
Good morning. Brendan Vaughn and Cheryl Kimball of the firm Keegan Werlin LLP on behalf of the United Illuminating Company.
Thank you.
Morning, Scott Thompson with my local counsel, Colleen Olson, on behalf of New England Connectivity and Telecommunications Association.
Good morning, Mark Cook on behalf of Crown Castle Fiber and Go NetSpeed.
Morning, Tom Wheel for the Office of Consumer Counsel. I'm joined by Consumer Counsel Claire Coleman, who will also, in addition to me, be offering oral argument.
Good morning. I am Jay Goodman of Couchwhite LLP, appearing on behalf of the Connecticut Industrial Energy Consumers, or CIEC.
Good morning. Susanna Nigro from the Department of Energy and Environmental Protection, and I'm joined today by Attorney Brendan Shane.
Morning, Commissioners. Tom Lopez on behalf of the Office of Education, Outreach, and Enforcement. Thank you.
Good morning, Commissioners. John Wright on behalf of the Office of the Attorney General. With me here today is Caroline McCormack. Thank you.
Thank you so much. Okay. Before we get into oral arguments, so as you all know, Chair Gillette recused herself from this proceeding and will not be participating in the commissioner's deliberation or the final decision. This has unfolded rather quickly this past week. And I just want to say I appreciate PR staff effort and being able to get the PFD out on time, and also to all the parties and interveners who filed their written exceptions and all the comments that we received earlier this week. But I do want to take this opportunity for a pause and ask parties to weigh in on remaining procedural schedule. The final decision is scheduled for October 28th. So in light of the recusal, we want to know if any parties or interveners feel that additional process is warranted. So I understand that you all came here today prepared for oral argument, but Commissioner Karen and I felt it was important to give everyone the opportunity to address the issue today. So given that we're just raising this now, I'd like to give the parties I want to take a recess, maybe give the parties 20 minutes-ish, 30 minutes to confer, and then we can reconvene. Are there any objections to a recess to allow parties to confer? Oh, seeing going once, going twice, seeing none. Okay, so let's take the recess, allow everyone to confer, and let's shoot to reconvene 9:35. Good. Okay, so thank you very much. We'll see you in a bit.
Hey, Tom? Yes. Yeah, we shot it. We can. Okay.
Yeah, I can't get away.
All right, we can, we'll go back on the record now. So what I'm going to do is I'll invite parties to come to the microphone, and let's just go in the order that everyone presented themselves in at the outset. And also just want to remark that, so we are going to ask for all requests to be filed as a written motion as well. And we're not going to rule from the bench today on the request, but the panel of commissioners will confer on all requests. So let's start with Attorney Vaughn, Attorney Kimball, UI first. Are they back?
Good morning, Vice Chairman and Commissioner. We have been discussing, we're in a discussion with the Attorney General's office, DEEP, and the company.
Oh, okay.
Their counsel is standing right outside.
Oh, okay.
We are going to ask if it's possible for us to have 20 more minutes of recess.
I don't see why not. So let's take another 20-minute recess and we'll reconvene. Let's just say 10 o'clock.
Thank you.
Okay, thanks. Sorry. Let's, we will, hold on, let me get situated first. 1 second, thanks. Okay, let's go back on the record. OCC?
I apologize. That's why I was trying to do it at the outset here. We were asking if we could, this time we were going to request if we could have until 11. That way we're not pulling people back in and out every 30 minutes at the rate it's been going. So if we could come back in at 11, and we believe we will have things resolved and ready to continue at that moment.
Okay. Attorney Kimball, would you like to approach or respond?
We don't think we need any more time. We're prepared to go forward. We are prepared to address your question. We've put a proposal on the table for them. It's not complicated, so we're ready to go forward. And I mean, I will just say that we are willing to extend the time for a final decision in this case, subject to an agreement by the other parties that the company would be made whole for any time that is lost here in the final result, whether it's resolved by some type of resolution or some type of decision of the commission. Like, we can make a provision for time, and we would like to work with the parties. I don't know what another hour is needed for, and we're prepared to move forward. We have some legal comments that we would like to go over. We do not need to cover rate issues today. If we would like to extend the schedule and try to work with other parties, we're happy to put a motion in writing that we would try to get the consensus of other people on that motion and put it in the next day. We're happy to do that, but I don't know what another hour is necessary for.
Okay, thank you. Would anyone else like to approach?
So Victoria Hackett for Deep. Our lawyer just went to go get everybody else who was sitting together, and we thought we could work toward some agreed upon language that would provide the framework for a short extension to determine. I guess the concern is that Pura would get stuck on the back end if we don't hold oral argument today. And if there isn't an agreement to extend the time, and Pura would have to renotice oral argument and not have much time on the back end to make its decision because of the statutory deadline. So we want to ensure that the record is clear on any agreement before we decide to waive oral argument on the substance today.
Okay, thank you. Would anyone else like to approach? Attorney Goodman?
Thank you. Jay Goodman for CIEC. I would just like to say that, to my knowledge, the discussions so far have been between the utility and the state entities, but not the other parties. To the extent that there will be some apparently negotiations over procedure moving forward, we'd ask that all of the parties be given the opportunity to participate and weigh in. Thank you.
Thank you. Would anyone else like to approach? Attorney Kimball, would you mind approaching just one more time? I just have a clarifying question. Are you objecting to the hour recess officially?
We want to do whatever the commission would like to do. I just think that it's unclear to me, like, what we're even talking about. It feels like a little bit like we should be moving forward, because we are willing to put something in writing, a motion in front of the commission, tomorrow, the next day, that would allow for additional time in the procedural schedule to work with all parties to try to come to a resolution. In fact, what we were going to ask for today at the end of our comments was that you direct the parties to try to come to a consensus resolution. And that would obviously require some additional time, and the company would need to work that out and would be willing to work that out. What's been done in the past is that you just are held harmless to that November 1 date. And that we've already received sign off from management to be able to extend it by 30 days, subject to a make whole to November 1. We could put a motion in, we can work with the parties. There is no other answer here. There has to be at least an attempt for a consensus resolution, at least an attempt. So we can take another hour if you prefer, if other people want to. I think we're ready to move forward. We'd like to go through our legal comments and file a motion for additional time.
Council, thank you, Attorney Kimball. Yeah, Council Coleman, would you like to approach?
Sure. Just to clarify the record, we're not in agreement with that as the pathway forward. What we had asked for, we do agree that there is potential for a resolution and it would benefit the authority to have additional time, and we're not objecting to that. But our concern is that the statutory timeline for a required final decision needs to be waived by the company in order to avoid the result of the company's full application being granted as if the clock was to be pushed out and run out. We're very cognizant of the fact that PURA, the authority and staff, has a lot of work to do on the back end here. It may be appropriate to issue a new draft decision. There's a lot of process. We're willing to sit down with the company and all of the parties and work out a timeline, but feel that the statutory waiver is a key component of that.
Deep, would you like to approach?
On behalf of Deep, we believe that absent an agreement on the record today, that we would want to move forward with oral argument on the issues.
The concern is that if we're relying on them to file a motion tomorrow, that we haven't all agreed to the language on that motion and what a waiver looks like and what any extension looks like, that could put PURE in a bad position if PURE decides to not rule in favor of the motion. Then PURE won't have had oral arguments and we'll have to reschedule oral arguments and still have enough time to write its decision before the deadline. So I think the choices are that we either reach language today that we present to you, or we move forward with oral arguments and try after that to talk about, timing. That's where we are.
Thank you.
Attorney Kimball.
Thank you.
It's okay.
We're not going to be able to reach settlement language in the room today on the motion. I think we would like to reach agreement on a motion to extend. We're not waiving, we're never going to waive the statutory deadline, but we will agree to extend it subject to the make-whole provision that I told you about. I don't think it makes sense to sit here and have everybody sitting here while we try to negotiate language for a motion in the other room. I think maybe it's better to just proceed forward, understanding that the commission's looking for potentially some consensus collaboration to see if we can resolve this. And we will work with the parties this afternoon, try to come up with the language once we're out of the room, and try to file something with the commission that would allow for that time. I don't see it as productive to try to sit out in the other room and negotiate language. We would just prefer to move forward with the statements we have prepared and work outside the room later today to meet your expectations.
Okay, thank you. Okay, so we're going to commence with oral argument today. We are going to, apologies, but we are going to take a little recess for ourselves. So let's commence with oral arguments at 10:30. And we'd also like for the parties to, as indicated, continue working collaboratively towards a consensus and, file a maybe joint motion, but motions in written form to the authority for a panel of commissioners to confer upon. So thank you. We'll be back in 20 minutes. We'll take a quick little recess. Thanks, everybody.
Good to see you. I don't see it. Oh, I don't. Yeah. Had a couple of days off. I think so. Well, actually, yeah. That's what I'm up to. High school soccer. They're pretty easy. Hey, that's fine. We don't have to be back here for. Or everything. Why is this an issue? My last time good though. Like that wasn't
This is fun times. We spin it back up. How are we doing? They did most of the popcorn walking for us. Defense. Now we have 8 gigs. So. Popcorn walking. I've been passing along. I gotta stop these things. How you doing? You do? It's fun, yeah.
Like, I did. Yeah, it has to. Cost for repair. We got some. Yeah, last couple of years were very good. That's kind of. Backing up that. Right. It's only. Should have breakfast.
Okay, we'll go back on the record. So we'll commence with oral argument. Just want to remind everyone, as the process stands today, it's everyone's opportunity for oral argument. So please avail yourselves of that, regardless of, the motion requests that come in tomorrow or later this week. So we will begin with the order of how everyone presented. So you, the company, Attorney Kimball or Vaughn.
Thank you. So just to reiterate, the company, we will plan to file a motion for some process, for some time. We'll work with the parties to do that. We'll get it in as soon as possible. And thank you for the opportunity. Okay. Vice Chairman Arconti and Commissioner Karen, it is both unfortunate and unfair that you are left holding the bag on this complex and unprecedented breakdown. We are happy to see that the Commission is recognizing that an alternative process needs to be implemented. Putting your signatures on any decision that is prepared and issued by PURA unilaterally is simply sending a decision up to the Superior Court on appeal for a finding of bias and prejudice and potential remand because the chair acted as presiding officer and prepared the draft decision from which you will be working. There is no way to cure this defect, and if I were in your shoes, I would not want to perpetuate the problem. So thank you for the alternative process, consideration of the alternative process. I'd like to cover some legal issues. I'm going to take some time to outline where Avangrid stands from a legal perspective and the reasons that we need a balanced resolution of this case. Where we stand today is highly unfortunate and even really sad for PURA's employees, for everyone in this room who has had to participate in this chaos for the past 5 years, for the employees of United Illuminating and the other utilities serving customers in Connecticut and other parties coming before PURA, and most of all for customers whose interests have not been served in any respect by the misconduct of Chair Gillette and General Counsel Muska, among others. I do need to say before I go further that this morning Avangrid and Eversource have jointly filed a motion for recusal of General Counsel Muska from all matters regarding the Avangrid and Eversource operating companies. General Counsel Muska has been directly involved in much of the misconduct that Chair Gillette engaged in, and he cannot continue to advise the Commission or PURA staff on legalities that he himself may not have abided by. There are many, many implications arising from the misconduct that has occurred behind the walls of PURA over the past 5 years due to the usurpation of authority by Chair Gillette. At this point, the crux of the matter is that PURA's work product is thoroughly tainted by bias and prejudgment. The processes employed by Chair Gillette were unlawful and her bias was openly expressed. It is wholly unclear how deep the bias and prejudgment runs in the agency at this point, and that's one of the biggest disappointments because historically, PURA staff was a highly experienced and professional staff capable of issuing both tough and fair decisions. Unfortunately, we now have to come to grips with the fact that the draft decision is fully compromised. It is not just a matter of correcting a few things to reach a better result. The draft decision is saturated with bias and prejudgment, and it is simply not possible for the Commission to rectify what is wrong in this decision. It exists on every page and in every single individual rate determination. In fact, signing off on any aspect of this draft decision will simply buy PURA new litigation, and in that litigation, the AG will have to concede the existence of bias and prejudgment because the AG has already conceded bias in defending Senator Needleman and Representative Steinberg against the possibility of depositions in the CNG and SCG appeal. There, the AG's office has asked the court to remand those rate decisions to PURA in their entirety and without further consideration by the court. With the existence of bias and prejudgment, a rate decision is invalidated. Nothing is salvaged by the chair's recusal yesterday or resignation on Friday after all this time. Recusal is long overdue. We've been seeking recusal since last year in response to the misconduct that we experienced in the CNG and SCG rate case. The company raised the issue of bias and prejudgment in this case beginning last April, and Pura took no action. We filed a motion for recusal on April 24th and again on May 9th with updated information. As the presiding officer, the chair delivered the draft decision on September 10th without even mentioning the outstanding motion for recusal in the decision, constituting reversible legal error. When bias is raised in an administrative proceeding, the law requires the agency to investigate and resolve that bias, and the chair did not do that before resigning last Friday, after the draft decision was issued. The situation before Pura is very serious, and it is not solved by the chair's resignation. The damage she caused is widespread and calls into question everything pending before Pura currently and everything done by the agency over the past 5 years. It's going to take time and a lot of collaboration by the utilities, Pura, and many other stakeholders to sort this all out. And I do want to say that the utilities, Avangrid and Eversource, are committed to that and are looking forward to a reset in a better operating environment. We do know a couple of things today, which are that United Illuminating has filed its case in this proceeding in accordance with law, and there must be a timely, fair, and balanced outcome. The draft decision is irretrievably tainted. It cannot be rectified by the remaining commissioners. Therefore, the outcome of this proceeding must be a consensus-based outcome if litigation is to be avoided. A negotiated resolution based on the record evidence and briefing positions of the parties and interveners can avoid an appeal. So briefly, I'm going to just walk you through the legal consequences of Chair Gillette's misconduct in terms of the legal proceedings that are ongoing outside of Pura and how it affects resolution of this docket. Outside Pura, we are seeking to get to the truth, and that doesn't go away because Chair Gillette has resigned. We have cases pending before the Connecticut Freedom of Information Commission. Here, we intend to show that Chair Gillette and General Counsel Muska have withheld public records, revealing that she had wrested control of a 3-person administrative panel by shutting her co-commissioners out of the deliberative process and co-opting or misleading staff as to the reasons for the isolation of the co-commissioners. Despite the resignation of Chair Gillette, our FOIA complaints will go forward, and these complaints will likely implicate General Counsel Muska in the improper handling of FOIA requests. The FOIA process allows complainants to subpoena witnesses to testify under oath. The companies expect to use this process to get to the truth. Second, Avangrid and Eversource have a request for declaratory judgment pending before Hartford Superior Court, Complex Litigation Division. Our request for a declaratory judgment is asking the court to declare that the process Pura has used and continues to use is in issuing executive secretary rulings is unlawful. In the civil proceeding, we intend to show that Chair Gillette was untruthful about the fact that she was issuing unilateral agency decisions by affixing the executive secretary's stamp on substantive rulings, portraying them as decisions of the authority and sending those rulings out to the parties without consulting her co-commissioners whose votes needed to be recorded in writing in order to constitute a decision of the authority. This misconduct affected hundreds of rulings and numerous dockets across all companies and non-utility parties. Last spring, Pura filed a motion to dismiss that action in civil court, and oral argument was held in August on Pura's motion to dismiss. A decision from the judge is pending. Once it is determined whether the request for declaratory judgment will move forward, we plan to subpoena witnesses to give testimony on Pura's internal communications, its internal procedures, and the potential actions taken by Chair Gillette and Attorney Muska to conceal the truth surrounding Chair Gillette's unilateral use of executive secretary rulings, as well as bias in our proceedings. Third, Avangrid has an administrative appeal pending before the New Britain Superior Court regarding last year's rate case for the CNG and SCG companies. In that proceeding, the judge has allowed discovery to determine the nature and extent of procedural irregularities occurring in the gas rate cases and the existence of actual bias arising from Chair Gillette's participation in the drafting of an opinion piece. that was published in December 2024 under the names of Senator Needleman and Representative Steinberg. That case will progress over the next several weeks and may result in additional depositions or further discovery to ascertain the authorship of the opinion piece and to examine the statements that General Counsel Muska has made under oath in that proceeding regarding internal procedures, which do not now appear to be truthful. In that proceeding, lawyers for Senator Needleman and Representative Steinberg recently filed 80 pages of pleadings opposing their possible deposition, and not one of those pages made any statement disavowing the fact that Chair Gillette wrote that op-ed. In that proceeding, the judge has already concluded that a disinterested observer could conclude that the author of the op-ed in question could have in some measure adjudged the facts of CNG's and SCG's applications before hearing the case, which is to say prejudged whether the rate increases were appropriate. The judge's finding on that point is significant here because the op-ed was published on December 19th, 2024, after the CNG and SCG final decisions were issued, but during both this proceeding for United Illuminating and the Yankee Gas rate case proceeding. Once fully revealed, the authorship of the op-ed will affect all of PURA's major dockets, including this docket. Therefore, our strong preference is to avoid new litigation and appeals and to reach a negotiated consensus resolution that could be brought to PURA for review and approval. We have deep concerns about PURA's ability, at least in the short term, to navigate a final decision that is not a consensus resolution. And there is so much work that has gone into this docket by the company's employees, by OCC, by the Attorney General's office, and by others. Everyone needs to move past this unfortunate experience and accomplish a reset. The record is fully briefed and parties have taken positions that can be negotiated into a consensus resolution. On behalf of United Illuminating, I can commit to you that we will work in good faith, humility, and restraint to seek a consensus resolution with OCC and other parties and interveners. A consensus resolution would avoid further appeal. To that end, without waiving any rights, we respectfully ask the Commission to direct or allow the parties to commence a process to reach a consensus result that could be placed in front of the Commission for approval and resolution of this case. Thank you very much.
Thank you, Attorney Kimball. Questions? No questions. Okay. All right, NECTA?
Thank you and good morning. I guess I'm following that with just a straight discussion of some of the issues in the proposed decision. I would just note, as was noted earlier, that we certainly would be interested in being involved in discussions of potential settlement, but they should be obviously involve all parties. On the currently proposed decision, I want to talk about two issues. One, the proposal to unify, quote unquote, all pole attachment rental rates at the FCC's quote unquote telecom rate. And then I also want to talk about the Commission's disallowance of make-ready costs for UI. We're asking that the Commission amend the proposed decision's proposal to unify all pole rental rates at the FCC's telecom rate. I want to give a little bit of background very quickly so that we understand what we're talking about. So since 2012, the authority has been applying the FCC's two formulas for calculating pole rental rates. Why are there two? In 1996, in the Telecommunications Act 1996, Congress told the FCC to add a rental rate formula for telecommunications providers separate from the cable rate. The FCC did that. And what happened was, over a short period of time, it became very clear that that telecom rate was leading to much higher rates for telecommunications providers. So in 2011, the FCC amended that telecom rate. And what it did is it didn't raise the cable rate to match the telecom rate. It amended the telecom rate to come down to effectively try to match the cable rate, assuming that all presumptive values apply. And again, in 2015, they reiterated this on reconsideration. What the commission is now seeing is that once you move away from the presumptive values for pole height and appurtenance investment, the two formulas start to divide again, and the telecom rate becomes a bit higher because the impact of taller average poles, which is an established fact in this case, leads to a difference between the two. What the proposed decision would have happen is that it would raise everyone's rates to the higher telecom rate. I would submit to you that proposal suffers from at least three problems. Two of them are procedural. There's no notice of this potential rate increase. There's no evidence supporting it. And number three, it flies in the face of public policy as recognized by the FCC. Let me go over those each very quickly. First of all, there's been no notice. Nobody asked that the rates be unified at the telecom rate. UI didn't request it, OCC didn't. The Go NetSpeed and Crown Castle have, for several proceedings now, asked that there be a unified rate, but they've always made it clear that they wanted it unified at the cable rate. So as a result, nobody addressed this issue of what would happen if the authority were to increase the cable rates the pole attachment rates for cable operators up to the telecom rate. If that had been raised, NECTA would have submitted testimony demonstrating the issues, the adverse impact on cable operators and their subscribers, the adverse impact on broadband deployment, a whole host of things that we were not had any reason to believe we needed to be addressing. So as a result, there's not substantial evidence in the record. The proposed decision, for example, says that increasing the rate to the telecom rate will have no adverse impact on cable operators. That's at page 235. There's no evidence addressing that. Nobody testified about what the impact would or wouldn't be on cable operators, on broadband deployment in the state, on cable consumers. So again, it's the decision is premised on conclusions that have no evidence to support them, much less substantial evidence. As I mentioned, it also just conflicts with well-established public policy, and candidly would make Connecticut an outlier. The FCC has, as I pointed out, and as we laid out in our exceptions, every time that this divide between the two formulas has developed, for whatever reason, there are mathematical reasons, some changes in the facts, like I said, the presumptive pole height, average pole height, has a greater impact on cable rates than on the telecom rates under the formula. But every time that the two have started to separate and telecom rates have gotten higher, the answer has never been, hey, let's raise cable rates. Rather, the FCC has every time lowered the telecom rate, recognizing that that is going to best serve the public interest in deployment, broadband deployment, and on consumer impact. So at a minimum, this current proceeding is not set up to appropriately be the grounds for making this significant change in what has been a long-standing way of calculating the rates on cable operators. The second point I wanted to talk about is the treatment of make-ready costs, pole replacements, and other kinds of make-ready. UI had included approximately $2 million for costs in, not 2 million, I was reading something else. Let me also point out that I'm not going to go over them now because I know you've read them. We had also raised a few other issues in our written exceptions about the telecom rate. I'm not going to go over each one. The main one, though, that I would point out is even if the authority is going to apply the telecom rate, we've been unable to replicate the calculation. I think UI said in their brief they also couldn't replicate it. We pointed out at least one error that we found where the wrong decimal was applied. Again, we would oppose application of the rate, but to the extent that it's being proposed, there appear to be errors in even how it's been applied. So let me now move on to the make-ready question. The authority's treatment of you.
Thompson,
Yeah,
before
sure.
before you do, let me go back before you start that one.
Of course.
In terms of the determining the rate, would you be suggesting that that should be something that would be a separate docket to address, or perhaps
At
working
a
group?
minimum, yes. I think our point would be that right now, the authority doesn't have evidence in front of it to address the impact, if any, that would result. I think that the FCC's guidance would show that the correct answer is to lower it to the cable rate. But my point is, you heard no witnesses talking about what would happen if you make this change. And is this the correct direction to go?
Okay, thank you. Please proceed.
Thank you. So as I was pointing out, the authority's treatment of UI's allocation of make-ready and pole replacement costs is another point. It would have profound implications, yet is unsupported by the evidence. The proposed decision asserts that there's a large, and let me just say, and we pointed this out in our written filings, this is what we think is really the causality versus correlation issue. The proposed decision asserts that there's a large disparity between the costs incurred and the amount recovered, quote unquote, from responsible parties. And that the proposed decision says that supports the finding the company has not acted prudently and efficiently. We disagree with that. There's no evidence that the quote unquote responsible party are the new attachers, are the existing attachers. OCC introduced no witnesses or evidence showing who the responsible party was that the company should have allocated it to. In fact, the company included records and explanations, and they lay it out in their exception as well, of how their processes worked to determine who should pay for various occurrences. The argument that it should all go to the new attachers is just inaccurate. There are plenty of things, and there's testimony on the record where they explain polls are out there for decades. Over that time, they deteriorate over time. The fact that someone applies to put a new attachment on that pole, and UI goes out, inspects the pole, and says, "Hey, this is deteriorated. It needs to be replaced as a matter of course because it's now reached a point of being violating safety codes, perhaps." That's their regular maintenance. It may have been precipitated by the attachment. In other words, that may have caused them to go inspect it, but that's not what caused the replacement. And that's candidly consistent with like the FCC's treatment of what's called pre-existing conditions. What our position is that there's record evidence. UI says the same, that they have records in place, they have procedures in place, and there's no evidence demonstrating that their allocation of the costs is inaccurate. What I would step back and say is, if this is now how things are going to proceed, it raises a host of issues that are also not addressed and that UI has raised about how does it get allocated. And these are also being addressed, as I understand, in there's a working group under 190152 RE01 that have been trying to deal with these issues. And so we don't think that the current record supports the idea that all of that cost was caused by new attachers or existing attachers.
So are you saying that the OCC's contention that the electric ratepayers are paying more than 80% of the costs of new poles and for new attachers should still be, your intention is that it should still be the responsibility of the utility company on behalf of the ratepayers.
Correct. Our contention is it is appropriate, and there's no evidence that UI has inappropriately allocated the cost of particular pole replacements, for example, to itself in those circumstances. So that there are types of pole replacements, quote unquote, make ready, that it's appropriate for the company to do. And the mere fact that someone has applied to do something on the pole, again, it may have precipitated UI recognizing that the work needed to be done. It doesn't mean that that applying company was the cause of the work that needed to be done. So it's entirely appropriate that the company, I guess, the proposed decision assumes that because the company has absorbed a lot of the cost, that there's a problem with that. What I'm suggesting is there's not evidence to support that. That in fact, the evidence from UI is they've looked at them, they've determined what the cost causer was. And so to suggest that it, simply because there's a lot, that it's being misallocated is inaccurate. Because in reality, again, if there had been witnesses to talk about how the pole attachments happen, they could have explained, things like deteriorating poles, things like that, that are appropriately on the company and within the rate base. And keep in mind that attaching parties then pay through the annual rental rate, right? Part of the annual rental formula is the company's investment in poles, in maintenance. So that's all recovered, that regular maintenance that may be precipitated by a new attachment is recovered through the rate base. And by rate base, I mean the pole attachment rental formula rate base, right, the other attachers. Does that answer? I hope that answers your question. Thank you. So we'll reserve any reply if there is any. Thank you.
Is that your questions? Crown Castle. Crown Castle.
Good morning, Vice Chair and Commissioner Karen. Mark Cook for Crown Castle and Go Net Speed. With respect to make ready costs, there is evidence in this proceeding that UI has allocated make ready costs to entities making new attachments. There is no evidence in the record, however, that shows that the $24 million in pole maintenance costs were caused by new attachers. In fact, Crown Castle and Go Net Speed agree that Crown Castle and Go Net Speed agree with UI that any pre-existing non-compliant conditions identified during the survey and engineering of the poles must be made compliant and are the responsibility of the pole owners. Pole maintenance costs are paid by attachers through the maintenance component of the FCC cable and telecom formulas. A portion of the costs for work performed by a pole owner to correct a pole not meeting NESC or electric utility standards not necessitated solely by an attacher are booked to FERC account 593 entitled Maintenance of Overhead Lines and FERC accounts 920 and 921 Administrative and General Expenses. And those costs are passed on to attachers in the form of annual rent payments, as my colleague Attorney Thompson stated. As a result, attachers have been paying and continue to pay their share of the ongoing capital costs, maintenance, administrative, and operational expenses associated with the pole's upkeep by pole owners in the form of annual rent payments. Regarding pole attachment rate formulas and the goal of broadband deployment to all corners of the state, there is no doubt that adopting the cable rate for all attachers is the best way to achieve federal and state broadband deployment goals, as well as generate healthy competition that will drive prices down for the Connecticut consumer. The FCC's 2011 pole attachment order sought to decrease the telecom rate in order to eliminate market distortions, promote competition, and foster broadband deployment. These federal aims are in lockstep with Connecticut's enactment of Public Act 21-159, an act concerning equitable access to broadband. In the same 2011 pole attachment order, the FCC noted that even in 2011, many of the states that self-regulate on pole attachment issues had adopted the FCC's cable rate formula for both cable and telecom attachers in order to reach those important common goals. And in 2015, the FCC took additional steps to reduce rates, acknowledging that reducing the telecom rate to the cable rate level would further numerous policy goals. Crown Castle and Go NetSpeed have previously endorsed a uniform rate based on the FCC's cable rate because reducing rates is in line with authority and FCC precedent and provides the best avenue to foster broadband deployment to every corner of the state. With respect to specific components of the pole attachment formula as proposed in the proposed decision, consistent with causation principles, any costs UI incurred in mutual aid of other utilities should not be incurred by attachers attached to UI poles. The approximately $2 million incurred by UI in mutual aid to other utilities was entered by UI into FERC account 593. Consistent with causation principles, no portion of that total mutual aid amount should be included in the maintenance component of an attacher's pole attachment formula, whether UI receives reimbursement of these costs or not. UI reported having received a portion of that total amount in reimbursement, but UI only credited a small amount back to account 593. The proposed decision proposes an adjustment based on the amount that UI had actually been reimbursed. However, since attachers should not incur any costs UI incurred in mutual aid of other utilities, the correct adjustment is to adjust the maintenance component of the pole attachment formula for the remaining balance that UI has not credited account 593. We know the same error that Attorney Thompson and NECTA noted in the percentage in the telecom pole rate formula should be revised from 0.67 to 0.66. And finally, Crown Castle and Go NetSpeed support the use of 2 years of test data in order to gauge a more representative sample size of the entire embedded base of account 364 investment for appurtenances. UI submitted the subject appurtenance sample data in Docket 22-0808 and was subject to cross-examination regarding it. Using that same data, NECTA's expert witness included a chart showing pole and non-pole investment from the 2 test years in her pre-filed testimony in this proceeding. And she also cited to NECTA's response in the prior proceeding. As a result, the authority and all stakeholders are able to rely on the 2 years of appurtenance sample data supplied by UI in order to gauge a more representative sample size of the entire embedded base of account 364 investment in pole and non-pole appurtenances. Thank you.
Thank you, Attorney Cook. OCC.
Good morning, Commissioners. So I wanted to start this morning by extending our sincere gratitude to you in your role as commissioners and to the entire Pura staff for their hard work on this rate case, as well as all of the work across the board. I know that being in public service is a really hard job, and your role in particularly requires you to make incredibly hard decisions every day, often multiple decisions every day. So we appreciate that, and we also acknowledge that decision-making can get harder when politics and media are swirling around, and certainly that has been the case here. I do want to clarify our perspective this morning that I relayed, that while that we are open to having discussions with the company and other parties on alternative resolutions to this case. After having oral arguments, however, after having oral arguments today, the authority can appropriately move toward a final decision. I made reference to the potential of a new draft decision earlier, and I want to clarify that was limited to a scenario where a settlement is contemplated. Absent that, our perspective is that the authority can move forward on the record that has already been developed and closed in this case. While there's been extensive briefing, there is not evidence on the record that demonstrates many of the assertions made this morning about the extent to which Chair Gillette or anyone else of concern was involved in the draft decision. That's simply not in the record. So the company's asking for new evidence to be considered. And to do that again, we believe they would need to reopen the record, which would require an extension of the statutory deadline requiring a decision within 360 days of their application. So, in the face of all of the noise surrounding this decision, what we're hoping is that the authority is able to focus on legal standards and evidence. The commission's job is to ensure that, quote, the level and structure of rates be sufficient, but no more than sufficient to allow public service, allow UI in this case to recover their operating costs, including appropriate staffing levels, capital costs, and the ability to attract capital and maintain their financial integrity. That is the standard under General Statute 16-19E A4, and that is what PURA should remain focused on. As acknowledged in our briefing and in the proposed final decision, UI also has an obligation to perform its public responsibilities with both economy and efficiency. And so it's incumbent on PURA to ensure that rates reflect prudent and efficient management. And given that public service mandate and obligation, it is appropriate to explore how that risk is appropriately placed. And from our perspective as consumer advocates, it's appropriate that the risk on the company, is greater than the risk we're asking ratepayers to take on. UI's brief and exceptions made the point that OCC's recommendations in this case would allow for more revenue than the PFD allows. This is true. And this is also a logical result of the process of a rate case where there are multiple parties contributing ideas and suggestions about the appropriate level of rates. We at OCC are just one party and appreciate that there are other stakeholders here and the work of EOE, the AG, DEEP, other advocates who are here to complement our role as advocates for consumers in this process. So with that framing, I want to address two of the issues raised in the company's exceptions and then turn the mic over to OCC's Legal and Regulatory Director, Tom Wheel. The 2 points that I wanted to address are the proposed workforce reductions and pole attachment costs. So with respect to the revenue authorized for UI employees and UI's indication that this would require 72 FTEs to be reduced, we believe and acknowledge it's the authority's job to balance rate-making principles with practical needs. So while our office did not recommend these cuts or take a position on them in briefing, we acknowledged in reading the decision that it is consistent with rate-making principles, right? Just because a company decides to add a certain level of employees doesn't mean they automatically receive the revenue correlated to it. That's part of the regulatory rate-making framework, particularly as in this case, The application included 72 new employees since their last rate case just 2 years ago that were above the authorized levels. Again, that was a risk that the company took on. And, we know that the authority acts in lieu of competition for the company to make sure it's operating as efficiently as possible. So we take that perspective, and then we also balance that with the current realities of our electric grid and energy challenges. I know personally that the issues in our office and the issues that the authority faces and the issues that the utility faces have become more complex and far-reaching. We are currently all engaged in moving forward with critical and ambitious grid modernization plans and plans that will allow our electric grid to become more efficient and user-friendly for customers. And we're going through a transition where distributed energy resources and other advanced technologies that support electric growth need to be connected to the electric grid. We also face frequent and damaging storms requiring storm response and proactive resilience planning to greater degrees than we've historically encountered. So we do greatly appreciate the authority as serving as a check to UI's inclination to go on, a hiring spree. We also know that the authority, and would ask that the authority keep these complexities in mind and certainly defer to the authority's judgment about using its expertise and discretion to balance these competing interests. The other issue that I wanted to address is pole attachments. First, a couple sort of clarifying technical points. The table on page 19 of the company's exceptions frames our recommendations as an adjustment, a $24.4 million revenue impact adjustment. That was a recommended rate base adjustment, which actually translates, the revenue impact there is about $3 million. The exceptions also suggested that these costs are only associated with the NESC compliance that the argument follows would benefit ratepayers, which we agree with. Obviously ensuring compliance with our polls does benefit ratepayers, but the record actually reflects that that these costs can and in fact are driven not only by UI and the need to maintain compliance with standards, but also, I think there was a quote by every entity on the poll potentially, and this is at the transcript on page 1524. So while we've heard that we've put no affirmative evidence in the record and the exceptions are framed as our position as a complete disavowal of ratepayer responsibilities for these costs, this is not accurate. We actually took the record that was developed, the information the companies provided, and we do encourage the authority to read our brief, which is between pages 130 and 141 on these points, where we explain that the issue here is that based on the evidence provided in discovery and in the transcript, that much of these costs are being caused in many cases by the attachment themselves. And electric ratepayers are being used as sort of a backstop because it's the easiest way to recoup funding. And that results in a truly overwhelming disparity between the contributions of pole attachers. As we noted in our brief, currently ratepayers are expected to shoulder about 98% of those costs, and that just isn't fair to ratepayers. So our argument was not that ratepayers shouldn't pay anything, but we need a better process to ensure that ratepayers are only paying for the parts that they're, the cost causer for. We do recognize and have read carefully the briefs from the companies and NECTA in response, and we are very cognizant of the fact that a full disallowance of these costs would, right or wrong, probably result in a reluctance to complete work, which I think we all view as critical to the state's goals. We at the OCC represent electric ratepayers, and we also deeply care about our mission to help expand broadband access for all state residents. So we certainly didn't make these recommendations lightly. And our goal is not to create a potential barrier for broadband deployment. It's really just to ensure that we have a fair process. So our brief suggested that UI, our initial proposed solution to this in our brief was to suggest that UI figure out the cost allocation issue and return in the next rate case to request that the appropriate level of plant be included in rate base and that it be disallowed in the meantime. Again, that was not to preclude recovery once the company demonstrated it had properly allocated costs. And we still do not support the inclusion of all pole attachment make-ready plant in rate base because again, some portion of that is not appropriately covered from ratepayers. However, given the public policy importance of ensuring broadband deployment, particularly while BEAD funding is still available and the benefits that greater broadband bring to all customers, many of whom are both electric ratepayers and telecom customers. We are suggesting a potential path forward could be the creation of a regulatory liability for this cost. So we would not object if the authority allowed the company to recover the requested revenue support for these investments. I think in their exceptions, they identified that as about 3.16 million. But so not to include it in rate base where it would be, continuous, but to treat the amount as a regulatory liability that would then be reconciled in the next rate case. So this we would see as a one-time solution that would permit the company the revenue it says it needs to facilitate broadband deployment, but still allow for the appropriate level of plant to enter rate base. And we do think it's critical if the authority were to move forward with this path, that there would be a process to clearly establish directives on improved cost sharing mechanisms. And I heard the question about potentially opening a proceeding to accomplish this. We certainly would embrace and actively participate in that proceeding. I think it's critical that we get this right and that there's clear expectations going forward so that we don't continue to have this problem. And finally, just with respect to the pole attachment outside expenses, we didn't challenge the number of poles expected to be processed in the rate year. We see the explanation in the draft decision as reasonable and supported by citations to the record, but we are also cognizant of the company's arguments that its internal resources are not in fact sufficient to process the number of pending requests. And we're generally aware that this is a significant backlog of pole attachment requests, and that backlog is a barrier to the state's current broadband deployment. So we would also not object to PURA's consideration of the arguments with respect to UI's expected rate year pole attachment application costs. Again, here we also believe there is a path forward to better protect ratepayers while ensuring broadband deployment is not slowed, and appreciate the authority's consideration of these new suggestions today. And with that, I'm going to turn it over to our esteemed legal and regulatory director to hit a couple other rate making issues.
Good morning, Tom Wheel for the Office of Consumer Counsel. I'm just going to cover the nerdy stuff and I'll get off. I did want to add one comment, an additional comment to Consumer Counsel Coleman's comments about the pole attachment and the comments earlier about the lack of record evidence. We pointed this out in our brief, but I just wanted to point out again, what the record reflects is that the company's current process is that when they're unable to determine whether a cost is caused by an attacher or should be allocated to ratepayers, they just assume it just gets tossed in the bucket that gets added to rate base. And that's OCC 791. The quote is, if an issue is identified and the cost causer cannot be readily determined, the company remediates the issue. And that's our problem here. As Consumer Counsel Coleman said before, our position is not that ratepayers shouldn't pay for any of this. We understand that this is a cost allocation issue. It's not an issue about that none of this is appropriately recoverable. And as Consumer Counsel Coleman suggested, we do think that there is a potential way to have a balanced resolution while we figure this out. But I did just want to, we also said this in our brief, and I think it's reflected in the draft decision. This also isn't news to the authority. The authority determined this same issue in Docket's 1901-52 REO1, saying non-billable make-ready work unfairly lands on electric distribution and other pole owner customers. and has already determined like this is an issue that needs to be figured out. So we're a little confused like why this is still like why that is still contentious today. I think the authorities already recognize like this is a problem, we got to solve it. So we're open to continuing discussions of how to solve it. We do think that the regulatory liability idea is a way to make sure that the company can have revenue now, but in a way where it isn't unretrievable retroactively. Like once we find out, oops, this $20 million, some portion of it shouldn't have been on ratepayers' backs. We think of setting it up as a regulatory liability that can be reconciled in the next rate case is a good path forward for that. The next issue I wanted to raise is one where I think there are a couple areas, as I think Consumer Counsel Coleman covered, there are a couple areas where we don't disagree with some of the issues the company raises in exceptions. And we would encourage the authority to take another look based on some of their arguments. And I think the only one, I'll cover two of those. The first is also related to pole attachments. With respect to the expense side, the disallowance of the outside resources for pole attachments, the draft decision does include a lot of record references and rationale for that disallowance. And among those is, I think maybe the final point is this reference to the pole attachment fee revenues. There's a suggestion that those revenues can be used to potentially offset some of the company's expenses. The company points out in its exceptions that those fees are also included in the RDM calculation, the revenue decoupling mechanism. So what essentially that means is that we agree with the company's understanding that the draft decision essentially says that the revenue that the company gets for those pole attachment fees should be included, should be sort of counted as the revenue that is reconciled to the authorized revenue through the revenue decoupling mechanism, which is an easier way to say that is that revenue goes back to ratepayers, that's a credit back to ratepayers through the RDM. So we agree kind of conceptually, just as a rate-making quandary, that revenue isn't going to be available to the company to offset its expenses as a result of that structure. So we understand UI's arguments on that point, and we don't disagree that could be something that the authority could take another look at in the final decision. The other issue the company raised with respect to minor storm costs, that was another area where the draft decision explains its reasoning at length and does appropriately cite to the record. And among the reasons I think that the disallowances are discussed is this idea that the company has been continuously investing has been continuously hardening its system, and conceptually that should mean that storm costs should be reduced. And we agree with that concept. I think that makes sense that, as we've all been, as the company's been continuously making increasing investment in resilience, the benefit of that should be a harder system that's harder, that doesn't experience the same level of outages in the face of, all else equal, the same level of threats. But what we also know is that the level of threats are increasing, right? Like we're talking about future rate years where we can't expect that storms will be consistent with the way they've been in the past. So it's a tough issue. Again, it's one where we understand the rationale from the proposed final decision. We're just not sure that the ultimate kind of resolution, as I understand it, in that portion of the PFD, is that it determines that about 50% of those costs, it determines that only about 50% of those costs should be allowable given the increasing investments in infrastructure. We're just not sure that specific adjustment, the authority could maybe explain more like how it arrived at that particular adjustment. One issue that we did not raise in our brief, but is included in the final decision, the proposed final decision, and that is included in the company's exceptions, is inflation. It's our understanding of the proposed final decision that there's several areas where inflation adjustments are disallowed on the basis that the company has essentially applied an inflation factor across all expenses that are increases from the historic test year into the rate year where there isn't a known and measurable adjustment. I see Commissioner Kieran shaking his head because I assume he's already heard me. If anyone's listened to the PBR discussions over the past 3 years, I think everyone's already heard the OCC talk about this. We do, so I'll reiterate it briefly, we do think that an inflation adjustment from any adjustment from the historic test year into the rate year should be based on some rationale, there should be, the company should be saying, here's why we expect this cost to go up or down. And that I want to be really clear. It is not at all that we don't believe that inflation exists. That's not true, but inflation absolutely exists. And inflation absolutely does impact a lot of the cost the companies incur. But there are also a lot of areas where it doesn't. And there are areas of this record. One that comes to mind is the adjustment. The company sought to recover membership dues in EPRI, and it applied an inflation adjustment to the historic test year costs. But then the rate year cost is lower than the historic test year cost. So that's an example where the company is saying they're making a known and measurable downward adjustment to the historic cost and then saying inflation applies to that. That it can't, right? Like that's deflation. And it's the same, we've raised this issue in other cases with respect to things like leases where inflation is a factor in the escalating cost of a lease for sure, but that's not the way leases work unless the lease itself escalates the cost in future years based on CPI or something. So my point is, we understand the rationale behind that adjustment, and I wanted to highlight that although we didn't articulate that in our brief in this case, we have raised it before, and that adjustment, which we think is, I believe it's 3.8 million across the PFD, that adjustment makes sense to us. I think the last issue I wanted to touch on is the disallowance of planned capital investment in the rate year. The proposed final decision, in our opinion, correctly explains that disallowance on the basis that the assets won't be used and useful. I know this is also one that everyone's heard the OCC's position on multiple times. And so we support that adjustment. That one was in our brief at length. I did want to take a moment to clarify the company's reply brief. Actually, there's a section in there where it talks about how OCC's position has been inconsistent over time. I think it's a fair argument, but I wanted to take this opportunity to explain to the authority sort of where we've come from. So the 3 cases that are discussed in the reply brief are 220808, which is UI's last rate case, 231102, which is the last CNG SCG rate case, and then this rate case. In 220808, it's important. The first thing I wanted to highlight is we actually didn't have a rate year plant adjustment recommendation in that case. If you go back and read our brief, we did have an adjustment to rate year plant, but it wasn't a complete disallowance. What the position we took in that case essentially was, in the future, there's a problem here. We wrote at length about the capital planning process at UI and our concerns about the lack of transparency, the lack of documentation, information asymmetry, risk shifting, a lot of stuff that we've discussed since then. All of that in that case was specific to capital planning. And essentially, our perspective on our position in that case was, this has got to be fixed in the future. We were asking PURA, Commissioner Karen might recall, this was the SFR conversation about like maybe a way to resolve this is to have some greater clarity on the expected level of filing in the future. But again, those were comments specific to the capital planning process and weren't related to a plant adjustment that we recommended. Then there's 231102, which was a gas case, which makes a huge difference from our perspective. We filed testimony talking about the future of gas, the uncertainty of the future of gas, the misalignment of gas planning potentially with the state's decarbonization goals. And that was the basis for our recommendation of no future plant should be allowed in that case. Especially in light of the energy transition. I mean, to put it bluntly, we're just not, I think we said this in this case, we filed testimony discussing whether it's necessary to have contemporaneous recovery of plant capital investments where the necessity for incremental investments might not be supported by state policy goals. We don't feel that way about electricity. Like, we acknowledge that the idea here in this energy transition is that we need more electric infrastructure, and in some ways, as a result, there's maybe less gas infrastructure. So we don't see those positions as being inconsistent because they're different industries. We would point the company and the authority to our position in the pending Yankee rate case where we took the same position, the consistent position there. In this case, our position ultimately came down to highlighting that from our perspective, we've been discussing the problems that we raised in 220808 for 3 years in the PBR docket, that like there has been this ongoing discussion in 2 of the PBR dockets about how to resolve this issue. Like, how do we balance the risks that parties like OCC have been raising with respect to just rate basing whatever we're expecting might get built in the future with the need to build things in the future. And we're on the precipice of coming up with solutions on that in the PBR docket. Those final decisions are obviously still pending, but there have been discussions about tools like the CT bar, tracking mechanisms, the IDSP plan. All of those things matter a lot and potentially resolve and go a long way towards resolving our concerns that we raised in the last electric rate case. So just for clarity, that's our position now, is that we're just on the verge of figuring this out. We can't go back to a pre-220808 world where just let us rate base whatever we think is going to happen in the future. Like that was our primary kind of position in this case. I do want to highlight though that with respect to documentation, this case, from our perspective, the documentation for plant already in service, in particular, in this case, has greatly resolved the concerns that we raised in the last rate case. We did try to, I hope the company saw our commendations in our brief on that issue. We very much appreciate the effort that the company has absolutely put into improving documentation, taking great steps to explain exactly what the documentation needs, how it's relevant to the case. They've been really, they've been responsive to us. Having discussions about them has been really much more effective. So we greatly appreciate it. We think the documentation that's provided in this case can and should be a model for other companies in future rate cases to look at, to like, this is resolving our concerns. So I want to make really clear, that's also why we didn't raise documentation across all plants in this case as an issue for us. And unless the authority has any questions, that's all we wanted to touch on this morning.
Thank you, Attorney Wheel. CIEC?
Good morning, Commissioners, and thank you for the opportunity to present today on behalf of the Connecticut Industrial Energy Consumers, or CIEC. I'd actually like to start by returning to a point of procedural discussion earlier today. The company has proposed an opportunity for settlement procedures to seek to develop a comprehensive settlement proposal that would resolve all issues in dispute in this proceeding. At least that was my understanding of what was said. And I also understood the company to say that that process, if we go forward with it, would be open to all interested parties in this proceeding. I think I also heard OCC say that, if I understood Attorney Coleman's comments correctly, that if there is to be a settlement process, that they also think that it should be open to all participants. And just want to state now that CIEC is open, and if there is an opportunity for settlement discussions, we would welcome the opportunity to join those discussions and seek to resolve seek to develop a comprehensive resolution of the issues in dispute in this proceeding. The key thing from our perspective is that that process is open to all interested parties from the very beginning. If some parties are either excluded from the start or only presented with a fully baked agreement negotiated by some parties approximately 24 or 48 hours before it is to be filed, we think that process would be inadequate. And to the extent that the proposal would, in part, be an attempt to avoid litigation and allegations of unfairness and lack of due process, any settlement process that is not open to all parties from the very beginning, I think would be subject to the same challenges. With that out of the way, I'd like to turn to the one issue that I'd planned to discuss today, specifically relating to the proposed special contract policy. And I understand the Commissioner's statement at the outset of the proceeding today that you've read our briefs And there's no need to summarize the positions advanced there. And I don't intend to do that, but I want to begin by just being clear on a couple points regarding our position so that, as I turn to the issue I want to address, there's no misunderstanding of kind of where we stand here. Our understanding of how the authority and UI would implement the special contract process is that applications will be evaluated on a case-by-case basis with consideration of all facts and circumstances that are relevant to that specific application, which may be approved for a limited and defined term. We agree with this approach because we agree with the authority's statement in the proposed final decision that this is not a process that can proceed under one-size-fits-all methodology. We also agree that any applicant should provide information that is sufficient to validate the stated need for a load retention rate incentive, and that the process should seek to minimize the risk of free ridership. The application review process, however, should include sufficient flexibility to enable that case-by-case examination of each application, which we think is consistent with what the authority stated in the proposed final decision should be conducted. We've explained that the financial challenges that lead to a potential loss of significant load and motivates a special contract application can generally manifest in two ways. One, the need can relate to the customer having a competitive, lower cost alternative to shift operations out of state, or the need can relate to financial conditions that threaten continued in-state operations without that competitive alternative. And I want to focus on that first scenario regarding the competitive alternatives and the requirement in the proposed final decision that all special contract applicants must provide a profit and loss or P&L statement, because a statement may not be necessary to validate the competitive alternative that warrants a special contract. And the requirement also can be a barrier to even applying for the contract in the first instance. First, again, to be clear, CIEC does not object to requiring that applicants provide financial information in the application. Our position is that the application should include financial and non-financial information that is necessary to validate the needs stated in the application, that validate that competitive alternative, and that the information necessary to accomplish that will depend largely on the particular facts and circumstances of each applicant and the competitive alternative. So instead of requiring that the application include a P&L statement, this information should be an optional element that the customer may elect to provide. Many large energy-intensive companies have facilities in multiple states and sometimes nations, and the cost of energy, both commodity and utility distribution services, can represent a significant portion of their annual operating costs. Having a viable competitive alternative means that the company can shift operations from the Connecticut facility, where the cost of electric distribution service is very high, to a location outside of Connecticut, where energy costs and therefore a material part of annual operating costs are lower. A P&L for the Connecticut facility will not necessarily facilitate evaluation of that competitive alternative. Simply looking at one view of the profitability of a single facility does not really demonstrate the viability of that competitive alternative. There's other information that we think would be more probative for that. The P&L statement alone also would not provide any insight into the broader considerations that a company would weigh in its evaluation of where to invest limited capital. Requiring a P&L statement, however, is likely to discourage companies from applying in the first instance for the load retention rate incentive that otherwise would help them to sustain their operations in Connecticut. Second, and to the latter point, the P&L statements are considered by many companies to be highly sensitive, to contain highly sensitive information that must be protected from inadvertent disclosure to the greatest extent possible. If the information were to be disclosed inadvertently, the applicant could suffer significant commercial harm, especially if the information were to be obtained by a competitor or vendor. Companies are thus very reluctant to share that sensitive financial information, even if UI considers the potential risk of disclosure to be low. For these reasons, requiring the P&L statement to be included in every application almost certainly would lead some companies to decide not to apply for the load retention rate incentive despite the need for relief and its ability to help them maintain operations in Connecticut. What we propose instead is that the applicant would provide information in its application and then work with the company to ensure that enough information, both financial and non-financial, is included in the application to justify the need for a special contract. It's important.
Attorney Goodwin, before you
Yes,
go on.
sure.
So who's going to evaluate this?
Well, I was getting to that.
Okay.
What's been proposed is that what UI proposed and what I assume, I don't recall the proposed final decision addressing, but what I assume the process would be is that the authority would evaluate it. UI stated in its proposed special contract policy that every special contract application will be presented to the authority for its review and approval. So this anticipated the next couple talking points, which I'll focus on now, which is that if UI and the applicant have the opportunity to develop the information they think is necessary and sufficient to demonstrate the viability of a competitive alternative and justify the need for a special contract application, it doesn't end there. That package of information, explanation, rationale will be presented to the authority for its review and approval. You presumably could either approve the special contract, deny it, or potentially even ask questions, request more information, supplemental, as it may be. So we think that through this process, there would be very low risk of free ridership or of granting a load retention rate incentive that hasn't been fully vetted and justified. We're not trying to avoid scrutiny. We're not trying to avoid sharing any financial information. There's just a particular type of information and document that is particularly sensitive, where we'd like to have the flexibility to have that as an optional piece of information submitted with the application.
So it wouldn't be in the application initially, but if it comes to the authority for review, the authority could provide a protective order and review consequently P&L statements within its purview of trying to determine whether this is a valid competitive alternative.
We're not suggesting that there be no application, and we're also not suggesting.
No. There would be no P&L required in the application necessarily, but ultimately before the authority signs off on it, the authority would have the opportunity under protective order to review any and all financial information it requires. Is that close to? Okay.
Yes, I believe that whatever information is provided in the application or subsequently developed in support of it would be presented to the authority for its review. And again, the proposal is that that package of information doesn't necessarily require a profit and loss statement to fully explain and validate the need for the special contract. Instead, it can be determined on a case-by-case basis, through your review and approval. So with that, I'd like to just take a step back. I mean, in this process, we're really focusing on kind of more granular implementation details in this case because the commission in UI's last rate case approved the special contract as, for policy reasons, as an opportunity to retain load at risk of loss. But I don't want to lose sight of what, we think those policy reasons are for approving the special contract process in the first instance. And I'd like to provide just a general hypothetical example to illustrate that. So from our perspective, a potential applicant could be a large energy intensive company that has a demand of at least a megawatt, potentially, many megawatts, and uses 1 million or more kilowatt hours of energy each month. Monthly utility bills can be hundreds of thousands of dollars. There are many examples of companies like this in Connecticut. And one of those companies can employ thousands of state residents, contribute millions of dollars annually to state and local taxes. The economic impact of the company can extend far and wide, given its reliance on in-state vendors for products and services, and that its employees are supporting local businesses with their wages. The facility may have operated in Connecticut for many years and prefer to continue doing so, all else equal. From time to time, however, competitive pressures for an energy-intensive company can force the consideration of alternate locations where material savings could be realized through lower utility rates and charges. In those circumstances, the load retention rate incentive we're talking about can play a critical role in helping to keep that load and its associated jobs and economic activity in Connecticut. We're advocating for the incentive to be implemented in a manner that is likely to satisfy both the policy needs of the authority, which we understand and respect, as well as the needs of potential applicants, so that Connecticut has an effective tool to retain at-risk load and help to preserve jobs and economic activity in Connecticut. Our recommendation, as narrow as it might be here regarding the P&L statement, to have that specific piece of information be an optional part of the application, we consider to be important to achieving that balance. Thank you for your time and attention to this, and I would welcome the opportunity to discuss the proposal further if you have any questions. Thank you.
Deep.
Good morning. I'm Susanna Nigro, and I'm here on behalf of the Department of Energy and Environmental Protection. I'm joined today by Attorney Brendan Shane and Attorney Sarah Solars on behalf of DEEP. I'm also joined by Bureau Chief Vicki Hackett and Senior Analyst Eric Annis from BETP. We would first like to thank the authority for your work and careful consideration in this docket and for the opportunity to appear before you today for oral argument. I would like to begin with brief comments and then turn the microphone over to Attorney Shane to address DEEP's written exceptions to related to English Station. First, DEEP respectfully requests that the authority adopt the OCC's arguments concerning pole attachment make-ready costs, specifically allowing the cost to be treated as a regulatory liability. DEEP presents this argument to the authority because it is the governor's priority to build out broadband across Connecticut, and we need participation and cooperation from United Illuminating for this to occur. DEEP is concerned about how the outcome of this decision might potentially affect DEEP's ability to move forward with the federally funded rollout of broadband that it is currently implementing. DEEP agrees with the proposed final decision's concerns about ratepayers bearing costs that are not attributable to them, and agrees with the concern that UI has not fulfilled its obligation to demonstrate the nexus between the need for replacement and the allocation to ratepayers. DEEP requests that the authority consider the adoption of OCC's recommendations, including that PURA allow the make-ready pole replacement costs to be treated as a regulatory liability. Next, in response to UI's argument, we believe that it is important to note that we don't concede that the draft decision in any way taints a final decision issued by the two commissioners on the bench today. You are hearing arguments today. You have time to take a fresh look at the record to consider the positions of the parties as raised in the briefs and written exceptions. You have generously offered additional process to the parties, an offer we are open to and continue to discuss and will continue to discuss with the other parties. If there is no additional process that occurs as a result of that, you have all of the tools necessary to make a valid decision and issue it on October 28th. Thank you for your time and consideration. At this point, I will turn the microphone over to Attorney Shane.
Good morning. For the record, my name is Brendan Shane. I'm the legal director for the Department's Environmental Quality Branch. I want to thank the authority for their continued attention to the remediation of English Station. We did file narrow exceptions to the proposed final decision to the extent that that decision characterizes UI's cleanup obligations. UI must spend at least $30 million on the remediation of English Station or return the balance of that money to the state, but that is not a cap on their obligation to clean up. Cleanup must be achieved notwithstanding the $30 million. To the extent that the proposed final decision characterizes the company's cleanup obligations under the partial consent order issued by the department, which was entered into the record by the company as Exhibit UI ERP 6, The department respectfully requests that those references be revised in a final decision to be consistent with the text of the partial consent order. Thank you.
Thank you. EOE.
Good morning, Commissioners. EOE has no additional oral argument to present. However, I did just want to take this opportunity to thank the Commissioners and Pura staff for their review of the record, and also thank the parties for the development of the record, and my staff at EOE for their hard work in this case. So that is all I have. Thank you.
Thank you.
Thank you.
Attorney General's office.
Sorry, I don't get this right. Thank you, Commissioners, for the opportunity to speak here today. As we indicated, we have no exceptions to the draft decision. UI didn't present any substantive critique of the draft decision today, so we will again avoid that in our comments. We have nothing prepared. We want to thank the opportunity to address the commissioners and the staff, and thank the staff in particular for the thorough, professional job they did with this draft decision. I do want to address some of the claims that were made by counsel today. There have been a lot of mudslinging and serious allegations of impropriety. Allegations against the chair, allegations against a large portion of Pura staff. And they're shocking allegations. I heard usurpation, misconduct, bias, and prejudgment going on for 5 full years. These are people you know, and you know these ugly claims are untrue. I know they're untrue. But the ugliness of the claims isn't really the point. Just making the smear helps the appeal process, which is what this is all about. It doesn't matter how small, every little bit helps. You've also heard other wild claims that the company's made here today, including that claims that the company has made on appeal for its affiliates before the Superior Court. They noted that the AG would concede the bias and prejudgment based upon the record of the CNG and SCG cases. Apologize for the volume changes. It may not surprise you that the Attorney General is in no way conceding or supports the company's position on those issues. They do not reflect the position of this office. We've said no such thing, nor has anyone in our office said any such thing. Full stop. I'd just like to make one last point. A number of the UI retirees have filed letters in this docket. I'm not sure it's properly presented in this docket, but about changes in their pension post-retirement benefits, and claims that those changes were done improperly. I don't know. These claims were raised late. Some of them were raised after the close of the record. And they're not raised in the proposed final decision, and I understand that. We do think these claims ought to be addressed, and this is just to put this before the commission now. It doesn't have to be in this particular proceeding. The record is closed. But if the record should open and the authority should deem it appropriate to review these claims, the Attorney General would think it was appropriate without commenting on the strength of the claims. We don't know. But there were some pretty convincing letters that were put out there, and we think it'd be appropriate to consider addressing that either here or in a separate proceeding. I have no further comments. I'd be happy to entertain any questions should you have any.
No questions. Thank you, Attorney General.
Thank you,
Office.
Commissioners.
Okay. I need a 5-minute break. So we will take a 5-minute break and commence with round 2. Thanks.
I don't want to.
All right. Give everyone a minute here. Let's go back on the record. We'll proceed with round two. Attorney Kimball, Attorney Yvonne.
Oh, thanks. Is this on? Okay, thank you. Okay, I'm just going to try to make this quick. Just a little bit of random comments. So in the CNG and SCG appeal, the AG's office has asked for a remand and recusal of the chair from the case. Send it back to Pura, remand it back to Pura with a recusal of the chair. So there's no lawful basis for the court to do that without first sustaining the appeal, which is on the basis of bias and prejudgment. So that has also already been conceded. Second, we appreciate all the comments on the rate determinations made in the draft decision, but our position continues to be that any final decision based on the draft decision will be invalid due to bias and prejudgment. Whatever changes you try to make or whatever you try to validate in the draft decision is entirely tainted and it cannot be cured, not with your signatures even. And we will be forced to appeal, which is what we do not want to do. Second, there's also a question as to whether the commission has a quorum to act unilaterally to issue a final decision based on the draft decision without a settled resolution. This is a significant factor counseling for a consensus resolution. If there's a consensus resolution, there is no appeal and the questions on quorum are avoided. So we need to state for the record that we do not waive any rights to challenge the validity of any decision on the basis of quorum that might be issued by Pura outside a consensus resolution. Lastly, we are not asking for the admission of new evidence. And also, I want to remind you that on August 30th, 2024, in docket number 231102, in the executive secretary ruling on motion number 118, the Chair Gillette stated, consistent with the Uniform Administrative Procedures Act, authority regulations and longstanding practice, all procedural, evidentiary, and other intermediate rulings in a contested proceeding are issued by the presiding officer. So Chair Gillette was the presiding officer in this docket. Therefore, according to Pura's own legal statements, the presiding officer is responsible for issuing any intermediate rulings, which would include the draft decision. So there is substantial, uncontested evidence of bias and prejudgment in the record with our 3 recusal motions, and any contention to the contrary is wrong. And I want to thank you so much for your attention and opening the door to that alternative resolution. And we will take the responsibility seriously and see what we can do.
Okay.
Thank you.
I appreciate that. I do want to talk a little policy, if you don't mind. I just have a couple of questions. Would the company respond to the the concept around the make-ready costs through a the proposal around regulatory liability?
Sure. I'm actually going to have somebody else. I do have two comments if you want to talk about the make ready and the draft decision. One is that there were certain costs that Pura in the decision has said that we are recovering through the revenues we get for pole attachments. But then the decision gives those revenues back to customers through the revenue decoupling mechanism. So we don't get the revenues. So that means we don't get that cost recovery. The second issue is all this capital that's gone into making sure that the poles are consistent and in compliance with the National Electric Safety Code. That is an electric system obligation. It is the obligation of the electric system to make sure that those poles are safe at all times. There has been this debate over whether and how somebody should know that somebody has stopped at the pole and done something to the pole, and we should be tracking down somebody to find the cost. But that was delegated to a working group under the supervision of EOE, which has not been able to resolve the issue or come up with any guidance. So in the meantime, short of having any other guidance, that has to be an electric system cost because the company has to have the poles in compliance with the NESC.
Oh, go ahead. So just to clarify on a regulatory liability, and I'm Andrea Van Leeuwen, I'm the networks controller here on behalf of UI. A regulatory liability can only be established if it is deferring revenue that was received. So the concept of a regulatory liability is money that was received from customers that must be repaid to customers. So if we're going to establish a regulatory liability mechanism, we'd have to be receiving the revenue for it. So I believe Attorney Wheel mentioned he had done the calculations and it was about $3 million. So if we're receiving the revenue, we would be okay with establishing a reg liability if we understood what the terms are for that regulatory liability. So what is it that we would need to do in order to keep the $3 million, and what would drive that $3 million needed to go back? And that $3 million would go back as the regulatory liability. Thank you.
Okay.
Is that it?
No, I'm thinking if I'm going to ask a specific follow-up. Sorry.
I'm not trying to
Um,
run.
It's okay. Just clarification on the company employee disallowance section. So the 72 employees is a combination of new hires and transfers from the service company, correct?
Correct.
So the employees that were transferred from the service company to the distribution company, their time is now 100% allocated to the distribution company. So for argument's sake, I would expect those employees not to put any hours, minutes into work on behalf of the shared services company
Correct.
going forward.
You're
Correct.
completely correct. For the utilities, if somebody's providing a shared service, they need to be in the service company. If they're not providing a shared service, they're in the distribution company, and they shouldn't be in the distribution company if they're providing any shared services.
Okay. And then one just question on the new Congress South project.
Mhm.
I'm referencing in the companies rent exceptions, page 31 and 32. So you reference, these conduits are in service, or your argument is that they're in service and they're used and useful, in that they were built out in this fashion to potentially serve new power. If, there is record evidence in the record that new power may or may not happen. So taking the scenario that it may not happen, and the fact that these conduits have their own retirement unit, at what point could customers in Bridgeport reasonably expect that they would be energized and serving the region?
Yes, so I think the overarching, can you hear me? I think the overarching point on the conduit issue is that it's the company's position that the conduits themselves are their own individual retirement account, booked to their own FERC account, and are used and useful once installed, that they do not require a conductor to be pulled through them in order to be added to rate base and to begin depreciating. Now, I understand, I think I understand the second part of your question to be, well, when might we expect a new power to come in? And I believe there are ongoing discussions with New Power. I'm seeing if Mr. Eves is in the room to correct me if I'm wrong. He may not be here, but I do believe that there have been discussions there, and I do believe that the company indicated that if New Power did enter into that that agreement with the company, that would be incorporated into.
So let's play out a scenario where new power doesn't happen and there's just no need in the future for cable and for these conduits to be energized. So they would just have been built and held in place for X amount of years. But the position of the company is just the fact that they're there the argument is that they're used and useful on behalf of customers.
So the company's position is that the scope of the project was to create a usable conduit system for the substation to points outside of the flood wall. And that's in our reply brief at pages 36 and 37. And that the company would have undertaken the full scope of the project at the time it was constructed, even if New Power did not require the interconnections. So the company's position is that while it was constructing that flood wall, it took advantage of the opportunity that it had to put the conduit through the flood wall, because otherwise waiting until, some greater electrification in the future would have cost significantly more money to put that conduit through, put the conduit and the conductor through the flood wall. It would have been prohibitively expensive. So the company undertook the installation of the conduit at this time. There's the New Power thing in concert with it, but it is available now to customers as load continues to grow.
Okay. No further questions on that topic. Thanks. I do just want to circle back. Sorry, I'm going to ask going back to the make ready. Sorry. You referenced the no guidance from the working group yet, but trying to go back into the record and docket number, the make ready docket 19, remember numbers off the top of my head, that there were some directives to the companies in that docket ultimately. So I guess my question is, why does the company feel like there needs to be more or different directives out of that working group versus the directives from the make ready?
So those directives would have come out in an uncontested docket, so it's not appealable. It doesn't really decide the application to a specific company. So when you come here in a rate case and decide that you're going to disallow $23 million of capital on the basis of a finding from an uncontested docket, it doesn't work legally. Here, you would need to find the company to be imprudent for having done that work. And that's what would need to happen. And that hasn't happened even in the draft decision. And so if you did want there to be some, if we're outside the prudence analysis and we just want to disallow some portion because we think it should have been allocated somewhere else, like we would need to have more specific detail about how that was going to be allocated between the parties, which didn't come out of that first docket.
Okay.
And I would get in trouble with Andrea if I didn't just go back to the, I don't want to get in trouble with her, but just to go back to the FTEs, I just wanted to make sure that it's clear that the 29 that transferred over, there was a credit to the service company of like $3.5–4 million. So the cost from the service company was brought down, the credit was taken in rates here, but then when the employees moved over, the cost wasn't added in distribution. So one of our even bigger problems is that you've deducted the costs from the service company, but haven't added the cost to distribution. It's like a double ding. So I just want to make sure that that's part of the answer.
Okay.
Okay, thank you so much.
Okay, thank you.
All right, thank you.
NECTA?
Thank you. Just a few issues on Make Ready. First of all, I want to agree with Council for UI about her statement that compliance with, keeping their polls in compliance with NESC is ultimately the company's obligation. I don't have a position on the proposed regulatory liability at this time, other than I want to make sure that there's a point made clear that, and it's unclear to me whether this is where this is leading, but we would certainly object to anything that led to a process or to claims where the company is going to like look back 2 years, 3 years, say to companies, oh, by the way, you now owe us for Make Ready that we didn't charge you for back then. When a company applies to attach to the polls, they are given a Make Ready estimate. They have the option at that point to reject it if it's too high. These companies accepted the Make Ready estimates, paid them, the work was done. To now have the, you know, we would certainly object to anything that led to years after the fact, oh, by the way, we now think that you owe us who knows however much, because at the time they may have, if that had been the estimate, they may have rejected it. But I will go back to, I think that the UI has evidence demonstrating that in fact, they did correctly allocate. I think that OCC during their argument talked at one point about some portion of it shouldn't be on ratepayers. So even I think they recognize now that it's inaccurate or too sweeping to suggest that all, whatever, 25 million or so shouldn't properly be allocated to the company. The reality is all, or, you know, if there was some mistake as to some particular poll, it doesn't undercut the idea that they've properly allocated at the time based on the facts on the ground at the time. So that's all I had to add. Again, mainly this concern about any retroactive true-ups that could lead to companies being faced with unexpected, you know, bills that we would have to then fight about, and that might impact the ability to deploy broadband further, or could have impacted the economics of what they did do.
Okay. No
Thank
further
you.
questions. Thank you. Crown, yes, Crown Castle.
Yes, similarly, we would object to any backward looking, because as stated at the time of the application, the attacher has the opportunity to decline the price of the Make Ready. And in addition, as UI has stated, when anytime an NESC violation is determined, its practice is to remediate the issue, bill the other poll owner if it's a jointly held poll, and to not bill any existing attacher. So I think we have that roadmap there, and we would also object to any backwards looking process. Thank you.
Question. Thank you. OCC?
Tom Wheel for OCC. I just have a couple of comments. I just wanted to make clear, Consumer Counsel Coleman made clear, I think, in her initial statement, but I want to make really clear, it has never been our position that ratepayers should not pay any amount of these poll attachment Make Ready costs. It's in our brief for pages and pages and pages. Maybe I'm not a very good writer. Maybe I need to be clearer in the way I write things, but I checked last night and it's pretty clear to me. Our proposal was come back for UI for this amount not to be included in rate base now, for UI to come back in their next rate case and hash this out and demonstrate what portion of this is properly to be included in rate base. So again, it was never our impression that we never meant to convey that like ratepayers should pay nothing for any of this. Our problem, again, is the cost allocation issue, again, that the authority already identified in an entirely different docket. Getting to that, I also want to respond. I understand the concerns of the pull attachments of that they don't want to have to be in a situation where UI is coming after them for costs that have already in their minds been finalized. I don't see how that can be a concern of the authority. I mean, it's fair to the authority to take that policy consideration under advisement, but the problem here is what the authority does is determine what ratepayers pay for. And I understand that what ratepayers don't pay for is paid by someone else, but that question is outside of the four corners of this rate case, in my opinion. With respect to I did want to address, Vice Chairman Arconti, your question about the regulatory liability proposal. I agree with what Ms. Van Luling said. Our proposal would be that the authority allow the revenue in this case, so adjust the revenue requirement to include the 3.16 million or whatever the appropriate calculation. Don't ever listen to me when I say numbers. Whatever the people who know how to do math say the right number is, that number should be included in rates. The company would recover that number, that level of revenue, and that would be the offset to the regulatory liability, I believe, that Ms. Van Luling was talking about. There's also the understandable question of sort of what would be the standard for recovery later. And the way we view it is it would be similar to the proposal in our brief, where UI would come back in its next rate case. It would presumably owe ratepayers that 3.16 million or whatever the number is, but could have the opportunity to prove it's less than that, because here we can demonstrate some portion of this 3.16 million was exclusively because of costs that had nothing to do with pull attachments. So that's our response, but hopefully that adds clarity that we don't disagree, that we are saying that our recommendation is that the company does get the revenue now as offset by the liability. I think the last thing I wanted to address, I'm not sure, I think I may have heard a question about quorum or a statement about quorum. I did just want to direct the authority to two cases. One is Lee versus Board of Education, 181 Con 69. It's a 1989 case. The second is Levinson versus Connecticut Board of Chiropractic Examiners, which is 211 Con 508. That's a 1989 case. We took a look at those cases because we had similar questions about how does this work in the absence of a third commissioner, and I'll leave it to the discretion of the authority's review of those cases, but our view of those cases, we believe the state of the law is that this commission can vote on this rate case under the current circumstances. So unless there are any further questions, that's all I had.
Thank you, Attorney Real. CIEC? Thank you. Deep? Thank you. EOE? Thank you so much. Attorney General's office.
Very briefly, thank you, commissioners. I just wanted to address UI's continuing representation that the AG in fact conceded that there was bias and misjudgment in the proceedings with Southern Connecticut Gas and Connecticut Natural Gas. That's simply not so, and in fact should matter. The page 2 of the motion to remand, that the authority, I assume the commissioners have a copy considering it was filed on your behalf. And I know that UI has a copy, but on page 2 of the motion to remand states, and I quote, the authority does not concede that the plaintiffs will demonstrate bias. And you can check that in the pleading. And I have nothing further but to set that record straight.
Okay.
Thank you.
Okay, thank you so much. Okay. That brings us to the end of oral arguments for today. Do you have any closing? Okay. All right, appreciate everyone's participation today. Encouraged by some of the discussions we had earlier, so we'll proceed day by day going forward. So with that, I'd like to close out today's oral arguments. We now stand adjourned, so see everybody next time and have a great weekend.